Good afternoon. This is a Delete Lawz video that was recommended to me by Bill Pearson? I don't know. Normally, people send me Delete Lawz videos that are like 2+ hours long. This is 24 minutes long. I've watched about 5 or so minutes of it. Just kind of give me an idea of what we're dealing with. And I can honestly say that it's very unimpressive. But to kind of put a fine point on it, this is the complaint that Chilli Decastro filed in Ohio in the Western Division, the Western Division of Ohio. This is in response to having his iPhone 12 Max Pro seized, and they haven't returned it to him. Well, apparently they seized it on March 29th or so. He demanded it back by April 6th. Then on April 13th, he filed this claim. And it is my understanding that there are ongoing criminal charges against him. He has not alleged in this complaint that any of the criminal charges that he was charged with have been dismissed. So obviously, any of this is going to be subject to the younger abstention doctrine, which means that the federal court is going to wait until the state court finishes with the underlying criminal prosecution before the federal court gets involved with the 1983 lawsuit. And that just happens. That just happens. That's the defendants are going to make a motion to suspend this particular case until the criminal trial is completed, and the federal court is going to grant that motion. Stay it, not suspend it, but you get what I'm saying. So anyway, this is a pretty stupid. This is pretty stupid. I only saw one exhibit, and it was the request for return of the phone. I haven't posted it here, but that's all I saw. Maybe there are more. I don't know. I don't really care. Whoever wrote this complaint, I think, is the same person who wrote the complaints for, what's that guy's name? Fred? The black guy out of Oklahoma who likes to fidget around with his hands to make the cops get all squirrely with him. Fred or Frank, or I don't remember what the hell his name was. And Earl both filed it, very similar. The reason why is because they use impropria persona and improper person down here. But if you look online at the Pacer file, it lists Chilli as being pro se. Generally speaking, state claims are filed in proper person or impropria persona. Generally speaking, at the federal level, they call them pro se litigants. Not that it makes a difference. It's not going to change anything. It's not that big of a deal. I'm just saying that I think it's the same person doing it. And there are some other things like when it lists the parties, like plaintiff Decastro at all times relevant herein suffered injury while in this district in the city of Ironton, Ohio. Okay. I don't know that you have to say at all times. I think you just have to allege that he suffered injury while in this district to establish venue. But he establishes jurisdiction and venue, and he's already pled that the events giving rise occurred in this district. So I think he's just filling out a form. Anyway, there's some other like weird things that I don't understand. Cause one, alleges a violation of the Fourth Amendment. The Fourth Amendment protects you from unreasonable searches and seizures, right? Unreasonable searches and seizures. The allegation in this is that, I got buzzed. Let's see what we got here. It's the wife. Got to respond to the wife. He alleges that the police failed to comply with state statutes, policies, and procedures when they encounter a plaintiff. Now, unless he's saying that they arrested him for something that wasn't a crime, or that they lacked probable cause for the arrest, or that they lacked reasonable suspicion for a detention, something along those lines, he's not actually alleging a violation of the Fourth Amendment. Saying that the police failed to comply with state statutes, policies, and procedures is a violation of state law, not federal law. The state actors don't violate your Fourth Amendment rights necessarily by failing to comply with state laws. So this is a 12b6 motion right here. This is a failure state a complaint upon which relief can be granted. And the court may allow, because the court can allow state causes of action to be pled with federal causes of action. The court can allow that. The court may allow the plaintiff to amend his complaint so that he's actually alleging which specific statutes, policies, and or procedures were violated, and to show that there is some sort of a remedy that the court can give for those violations. Because just because the cops may have violated a policy or something doesn't mean you can sue them over it. That's the whole thing where like you have to establish that they have a duty, some sort of a duty to you. And either that's going to be spelled out in some statute that says that you can sue them for it, or there's going to be some common law right to sue them for it. But anyway, cause one is just dookie. Cause two, it's another Fourth Amendment violation. So remember, this has got to be an unreasonable search or seizure. And in this one, they allege that the defendant knew or should have known that a person refusing to provide a social security number in order to complete processing of an arrest is not a violation of any law. Further, that it is a Fourth Amendment violation when compelling someone to do so under threat of punishment. I'm not aware of that. I'm not aware that they can't demand your social security number. Now, whether or not there's some punishment for you failing to provide it, I don't know. They alleged further up this complaint that they would hold Decastro for 3 months until the FBI verified who Decastro was. Now, I don't know why they would do that, or if that is an actual thing. Assuming it to be true, that seems, I don't know, that just seems kind of weird. Maybe they said we can hold you for up to this amount of time, or it could take this amount of time to verify who you are if you don't provide it. I'm assuming they were asking him that because he did not have a state-issued ID on him, which is normally sufficient to verify who you are. Otherwise, they're going to need other identifying information, like your name, your date of birth, maybe your social security number. I'm not aware that it's a Fourth Amendment violation, because remember, it's an unlawful search, and asking someone their social security number, asking them questions is not a search. There may be some sort of a Miranda violation in there, maybe if somehow if he had stated that he didn't want to answer questions until he had an attorney, or if he asserted his right to remain silent. I mean, this is an administrative thing, so maybe, I don't know, but maybe you could make an argument that there's some sort of a Fifth Amendment due process violation under Miranda. But this isn't Fourth Amendment. It's a totally different statute. So this one is probably going to be 12b6, or the court may allow the plaintiff to amend it. Cause 3, 14th Amendment violation, due process. I don't know what the hell. 14th Amendment, applies Fifth Amendment to the states. A due process violation, there's either a substantive due process or a procedural due process. Miranda, for example, is a substantive due process. Your right to privacy is substantive due process. And the procedural due process means you get notice and a hearing and, all that other fun stuff. Procedural obviously has to do with the procedure of taking away someone's life, liberty, or property. And the substantive means that you might have like some other interest in a thing. Like you have a substantive due process interest in benefits. They can't take your benefits away from you, like your Social Security benefits away from you without no, that would be a procedural due process. You have substantive is like the right to privacy. Yeah. And things along those lines. Was that Loving versus Virginia? It's like a right to marry who you want kind of thing. Those are substantive due process. The things that you need to make your other 10th Amendment or Bill of Rights work. Like it's things that are so ingrained in fairness and in society that they're substantive due process. I'm giving a horrible definition of it, but I don't want to take the time to look up the actual definition of it to give it to you. But it's along those lines. It doesn't have anything to do with holding a citizen's personal property. First of all, I'm going to assume, without knowing, that the state has withheld his phone. And by the state, I mean the city of Ironton and or the county of Ironton, whoever the prosecuting government entity is. Usually it's stylized as like the state of Ohio versus Chilli, Decastro. So that's why I say the state. But I mean, whoever. The people who have the phone are probably keeping the phone because they have probable cause that there's evidence on the phone. Maybe they have a warrant to search it. Maybe they are in the process of getting it. I don't know. I don't really care. But normally there is some sort of a remedy that you can seek at the state level to get back your phone. For instance, in California, you would file a 1538.5 motion. They literally call it a 1538.5 motion. It is out of California's Penal Code, section 1538.5, and it says that you can get back any tangible or intangible thing, the return of property, or suppression of evidence of any tangible or intangible thing obtained as a result of a search or seizure based on a search without a warrant being unreasonable, or a search with a warrant was unreasonable because the warrant was insufficient on its face, the property or evidence obtained is not that which was described in the warrant, or there was not probable cause for the issuance of the warrant, or the method for execution of the warrant violated federal or state constitutional standards, or there was any other violation of state or federal constitutional standards. So you would file this 1538.5 motion in the court, and you would simultaneously ask that the evidence be suppressed and that the property be returned to you. Ta-da! You don't have to file a 1983 lawsuit for it. But in this case, what he's really wanting to allege is that there was a Fourth Amendment violation, that the seizure of the property was unreasonable. And that's what he's going to have to prove. So again, because he's alleging a 14th Amendment due process violation, the court is likely going to allow him to amend this to be a Fourth Amendment violation. Cause 4 is a violation of the First Amendment, and he's saying that the state acted to arrest him and take his device from him to prevent him from expressing his First Amendment constitutional rights. However, you may notice that he is still filming things, and you may also notice that he's saying that they took his main recording device. Now, whether or not they could take his main recording device is really dependent on whether or not it was reasonable for them to seize it. And as soon as it ceases for them to be reasonable to keep that device, they have to return it. But he has to prove that. And it's not a First Amendment violation. So this, again, the court is most likely going to give him leave to amend this. This is actually a Fourth Amendment cause of action. And then cause 5 is another Fourth Amendment cause of action about the Social Security number, which is exactly the same as cause 2. So these are duplicative. So, I mean, you can only plead a cause of action once, so I don't know what to do on that. And then cause 6 is a violation of the 14th Amendment. I'm assuming a deprivation of life, liberty, or property without due process of law. Maybe, I don't know. So false arrest. False arrest. I think he's trying to plead the Thompson versus Clark case, the unreasonable search and seizure that the Supreme Court has called a malicious prosecution. I actually agree with Alito's dissent in this case because, yeah. Anyway, but I guess now it's malicious prosecution, but that is a Fourth Amendment. To maintain a Fourth Amendment claim under 1983 for malicious prosecution. So that's what he's shooting for, not 14th Amendment. And, you know, the reason why I have Thompson versus Clark up here, I don't need the Oyez up there. I just use that to get to the Justia. The reason why I have Thompson versus Clark up here is because Decastro actually talks about Thompson versus Clark. And so you would assume that someone who's talking about Thompson versus Clark would understand that Thompson versus Clark was a Fourth Amendment claim. You would assume that. One would assume a constitutional scholar with 20 plus years of studying the Constitution would understand that it was a Fourth Amendment claim. And yet here we have a violation of the 14th Amendment. And you could say, well, you know, maybe it was a typo. Maybe he meant Fourth Amendment, but he repeats it. So it's twice in there. I can only assume 3 times in there. I can only assume that if you do something 3 times, it's intentional and not a typo. Maybe it is a typo. And if that's so, then I apologize. But this one, I think the court will understand what he wants. And this is probably sufficient to put opposing this Jane Doe on notice as to what the actual allegation is. But when the 12B6 comes through and Decastro asks to be able to amend his complaint, you probably want to amend this one to actually allege a Fourth Amendment violation. Just a helpful suggestion from a first-year family law attorney. Now, again, the very first thing that's going to happen, it's already been served. There are already attorneys on the other side, is they're going to move the court. Oh, there's another one. There's a cause 7. They're going to move the court, younger abstention doctrine, to suspend the case until the criminal charges are complete. So a Monell claim is just saying that there are policies or hiring practice or whatever that the city or the county or the state uses that are causing the police to violate your rights. And he kind of muddles through it. I have read it. He kind of muddles through it. He's alleging failure to properly train, failure to properly supervise, but he also alleges the training and supervision of policymakers. I think what he's trying to say is that there are policies in place that encourage or allow the officers to violate his otherwise protected rights. So there you go. Interestingly enough, in the prayer for relief, is that he demands $1.1 million, $100,000 for punitive damages, and then exemplary damages of $1 million. Now, you're going to ask me, what's the difference between punitive damages and exemplary damages? And I don't know. California, we use those two words interchangeably. So I don't know. I have always used them interchangeably. Punitive damages are exemplary damages, and exemplary damages are punitive damages. So I don't know what he's doing there. Also, he never asks in his prayer for relief, he never asks for the return of the phone. Again, I don't know what he's doing. I'm not a mind reader. He literally doesn't ask for it. So I don't know what he's doing. It's sought against each defendant's officers, employees, and agents. Oh, the declaratory relief. Okay. And the declaratory relief, he's asking for, where is his declaratory relief? He doesn't ask for declaratory relief. So there you go. Okay. Okay, I guess he has it up here. This is the declaratory relief that each and every defendant violated his rights, and he seeks that declaratory relief against each defendant's officers, employees, and agents. I don't know. Whatever. Anyway, so with that understanding that he doesn't really seem to know what he's doing, or let me rephrase that. Whoever he had prepare this complaint for him doesn't really know what they're doing. They're going through the motions. They're doing things, but I've seen attorneys prepare worse. I'll be perfectly honest with you. But this is not by any stretch of the imagination a well-written complaint. So another thing is so now we're on to the video. CH and TY Audit, contact me. We want this. Give us a smoke. Number one, just so that everybody out there is aware, attorneys are prohibited from soliciting business. And by soliciting, I mean approaching someone that they know or believe has a valid complaint that they could file, and asking to represent them. You could have commercials out there just speaking generally to everybody, saying, if you've been injured in an auto accident, call me. I'll get you every penny or whatever. That's fine. But if you know that Joe Bob McGillicuddy just got in a car accident, you can't chase that ambulance down and hand Joe Bob McGillicuddy your card and say, hey, I want to represent you in your lawsuit against the driver of the other car. And why I'm bringing that up is because there are no rules of professional conduct for Chilli Decastro, Chilli Decastro, right? He may or may not, and I don't know all the things he's doing. He may or may not be violating various state laws on the practice of law. Some states might find that what he's doing is practicing law. I don't know. I don't care. I'm not making any judgments about that. I'm saying that may happen. And if that happens, then obviously there would be some oversight on him because a state may get involved and file charges against him. But attorneys they're responsible for following rules of professional conduct. Like in California, not only do you have the rules of professional conduct, we have the Business and Professions Code, which has a lot of paper devoted to making sure that attorneys are honest and upright citizens. For example, there's this catch-all provision in the Business and Professions Code that if you do anything, if you're convicted of anything involving moral turpitude, like tax evasion or something like that, or getting a DUI. If you get a DUI, if you're an attorney in California and you get a DUI, you can get sanctioned by the state bar for getting a DUI. I mean, I'm not saying getting a DUI while you're about your client's business or headed to the court or something like that. I'm talking about on your own time, on a weekend, on your own time, when you're not even representing anybody at all. You don't even have any ongoing cases, period. You're not representing anybody at all, but you get a DUI, boom, you can get sanctioned. There are a lot of regulations on attorneys. There are none on Chilli Decastro. So just be aware of that. Like, he can say some stupid shit, and he says a lot of stupid shit in here. He can say some stupid shit and get away with it, whereas an attorney can't. So I think we have it on 1.5. I think I'm actually going to jack it up because this thing's, I hope you could follow along. I hope you could hear it and follow along. We're going to go through this as fast as we can. It's all pretty much garbage anyway.
Okay, very limited time today. Very limited time. Got a lot of cases going on. So listen.
So he goes a lot about this very limited time. Got a lot of cases going on, right? He's super busy. You know, his time's valuable. Yeah, I mean, he's a salesman. A lot of the things he's doing in here are sales techniques. He picked the background that he picked for a reason. He picked the camera placement for a reason, because when he's looking directly into the camera, you don't see any glare of any lights. Here in a second, he'll turn on another light, because if you notice that right now, this side of his face is in shadow. So he's going to turn on a light so that that side of his face is no longer in shadow, because he wants to make sure that the lighting is exactly right. And he's going to go on and on about how he hasn't had time to groom himself, but you'll notice that his hair is perfectly done and he has a fresh shave. There's no stubble or anything on his face. I think he's wearing eyeliner. He may or may not be. I think he plucks his eyebrows. He may or may not. But this man, I mean, his neck, no hair on his neck, no hair on his chest. The man is very well groomed. So if you think that he doesn't have a lot of time, well, I don't know about that. Oh, yeah. And we want this, give us a smoke. I didn't understand what he meant by that. Apparently, it means that a phrase used to start an issue or emphasize how much an individual wants conflict to occur with another person regarding or referring to gun smoke, i.e., F them, I want all the smoke. So I'm not, whatever. So anyway, he's going to make a lot of very direct eye contact when he can, like when he was wanting to emphasize a point, because direct eye contact means that you can trust him. If he's looking at you in the eye, that means you could trust him. It's a sales technique. It's a sales technique. He wants to make sure that everybody's involved. You know, it's not just me, it's everybody. We're all in this together, i.e. give me money. He's going to make a lot of pitches about money, some that are overt, some that are subtle. But he's definitely trying to get, he's got super chats enabled. You'll see super chats pop up. He's got a subscribe button. You could buy the trifold that he sells on indestructible paperwork or indestructible paper from the website DeleteLawz.com for $25. I mean, he is in this to make money. Don't let him at all convince you otherwise. He is about money. He's doing this to make a living.
I need CH and TY audits. I need their people to reach out to me. This particular scenario is exactly what we want. I'm not saying that we're enjoying the idea. Hold on a second.
He's got to turn on a light. There you go.
Saying that we enjoy the.
He's got the light on. Now he has less shade here. And also it's a nice warm light. It really brings out the color, don't you think? He wants CH and TY's people, because this is what we want. This is what we want. And he's going to tell us exactly how he's going to pursue it, except at least as far as I watched, which was about 7 or 8 minutes into it, he did not say what he wanted. He just said vague platitudes and word salad about things generally.
The idea that this guy was wrongfully arrested. What I'm saying is this is the case that we need to take on. So I want his parents, his family, his best friend, his cousin, his brother, his uncle. I want them to reach out to me
because they can't file anything. It has to be C and H. CH has to file it because CH was the one, unless CH died in prison or something like that, and now his estate has the right to sue or something like that.
My team, the team that I'm on, the team that I'm a part of, our
my team. You don't have a team, dude.
Team. We have talked about this case, and we want to help assist with the legal paperwork and the filing. Because here's the thing: for this gentleman,
we want to help assist with the legal paperwork and the filing. Okay. Wife texting me again. Sorry. So, you know, if the paperwork and the filing is this quality, I would suggest that maybe that's not what you want to do. You may not want to hire this gentleman to prepare your documents. And just so everybody is aware, I'm not seeking to represent CH and TY. What I would recommend for CH and TY to do, or whoever, the guy who got arrested, if he believes that he has a valid claim, if he thinks that he has a case, then he should go to a local attorney and see if that local attorney is willing to represent him. If that local attorney is willing to represent him, then he should see if that local attorney is willing to represent him on a contingency fee basis. That means that the attorney only gets paid if the guy who's retaining him gets paid. And usually it's for some percentage of the return. And that's negotiable. I've seen anywhere from 25% all the way up to 50% of the net settlement or of the net judgment is what the attorney is entitled to. So if the attorney is willing to take it on contingency fee, you know that you have a good case. You know that attorney believes that he's going to get paid, that you're going to win, number one, and that you're going to win enough money to make it worth the attorney's time. If the attorney is willing to take it, but not on a contingency fee basis, then you have to think to yourself, well, that means the attorney either thinks that I'm not going to win, or the attorney thinks that if I do win, I'm not going to win much money, not enough money to make it worth the attorney's time, or a combination of the two. And if the attorney's not willing to take it at all, that means the attorney most likely thinks that it's a frivolous filing. And attorneys, unlike Chilli Decastro, attorneys can get sanctioned, not just by the courts, but by state bar associations, for filing frivolous lawsuits, but for filing frivolous pleadings and filings.
To hire a civil rights attorney, it's going to cost him between $40,000 to $60,000 at a very minimum. And then,
well, so I mean, it might not be out of pocket costs, but it could cost you that much money. Like, let's say you get $1 million settlement, and the attorney's entitled to 25% of it. If you net $800,000 out of that $1 million settlement, I don't know how you get $200,000 in fees and costs, but let's just, for round numbers, let's say you get $800,000 out of it. That means the attorney is going to get $200,000, 25% of $800,000, right? So you could say that attorney cost you $200,000, or you could say that attorney gave you or got for you $600,000. Now, if you're paying out of pocket, it's going to be expensive. Yes, civil rights attorneys are expensive out of pocket. But if you have a good case that you're going to get paid out of, then the attorneys are most likely going to be willing to do it for you on a contingency fee basis. But it would be better to hire a professional than to hire an amateur who writes stuff like this.
And the civil rights attorney, there is a bigger goal here than just winning one case.
So winning the case is important. If you don't win, that means it's going to cost you either more money to appeal it and appeal it again to the Supreme Court, or you just have lost and you don't get anything. If you win, you get paid, and that's a good thing. Now, if you want to actually take it to a court of appeals or to the Supreme Court, that means you have to lose at the trial court level. Do you want to lose at the trial court level? Do you want to pay? If you think a trial attorney for civil rights litigation is expensive, you should see what attorneys who specialize in appeals cost. It's a lot tougher field to be in. It's a lot more rigorous in what you have to show, and they get pricey. So I would suggest to you that you get an attorney and maybe you win right there, instead of going with the Chilli Decastro method, losing and taking it all the way to the Supreme Court. If you can get there. There are thousands and thousands of petitions for certiorari that the Supreme Court gets every year. Tens of thousands. And a relatively small handful get through. So, yeah, I mean, good luck.
Civil liberties do not end at the courtroom door.
No one argues that your civil liberties end at the courtroom door. There are certain places where there are certain places where the government can restrict your rights more than in other places. For example, I don't think anybody is going to suggest that you don't have civil liberties in prison. However, because you are in prison, the government has a lot more authority to restrict your rights. They can restrict your freedom of movement. They can restrict your freedom of association much more than they can if you're out in public. If you're on parole, you have even more freedoms. The government can restrict you less, but they can still give you lots of restrictions. They can say you can't have a firearm because you're on parole or probation or whatever. So there are always your civil rights aren't absolute. There are times and places where they can be restricted. Even your First Amendment can be restricted anytime and anywhere, subject to the strict scrutiny standard, where the government has a compelling government interest and the restriction on your speech is narrowly tailored and is the least restrictive that it could possibly be. And there are no other alternatives. Yada, yada. I mean, the government can do it. And if it's a forum analysis, if the government is trying to restrict your speech in a public park, there's still an analysis. It's subject to reasonable time, place, and manner restrictions. If it is a reasonable time, place, and manner restriction, then there has to be an important or significant government interest, and the regulation or rule has to be narrowly tailored to achieve that important or significant government interest. And you have to leave open ample alternative channels, yada yada, on all the. But the government can restrict strict scrutiny, intermediate scrutiny, reasonable or rational basis review. There's always the government can do stuff as long as it meets certain criteria. And no one is saying that your civil liberties end at the courtroom door. I think we're talking about a courthouse, but I'm saying I'm talking free talking, and I'm sure that on paper, if you wrote down what I said, I'd look like a blithering idiot. But so I understand, like he misspoke. He meant the courthouse door. But yeah, your civil liberties are more curtailed once you walk through that courthouse door than they were while you were on the sidewalk. They are. They don't end, but you have fewer available to you inside a courthouse than you did on the street.
Simply don't. And now, since we all have these magical smartphones in my hand where I can broadcast and get to thousands and thousands of people, I can turn this camera on and thousands of people.
Yeah, we know how smartphones and YouTube work, Chilli.
Here, we didn't get to see what happened. I think was the guy's name Josh? Was his name? I'd like to say.
Because of smartphones, we didn't get to see what happened. I'm pretty sure that he got in trouble for live streaming it. I'm pretty sure that he live streamed himself violating a judge's order. I'm pretty sure that's what happened. We did get to see it.
Say his name, but I don't know his name. I just saw Brian's. I'm so busy, but Beastmaster, good to see you. Accountability for all of them. God bless you guys.
I'm so busy, but let me do my shout outs. Whoops.
Number one, but I know where you're from. I literally have. Listen, I gotta go get a haircut. I haven't groomed myself in so long. You have no idea. I was behind on my.
Yeah. Freshly shaven face. Yeah.
Who cares about my
Well, you care. That's why you bring it up.
own personal strife? There's a man sitting in solitary confinement right now.
Who says he's sitting in solitary confinement? I haven't seen anything about him sitting in solitary. He's in jail, sure, but why is he in solitary? Damn it. My mouse double clicks sometimes. I gotta stop using the mouse.
They put him in solitary confinement. Do you know why they did that? To deter him from ever wanting to stand up against the tyrannical state again. We want to get this.
I don't think so. I think they did it to punish him for violating a judge's order. I think it is specifically a punishment for violating a judge's order. As long as he doesn't violate a judge's order, I think he's going to be okay.
Is filed properly. It has to be filed properly. So just so you guys know, it
has to be filed properly. Filing is the actual method of getting it past the clerk into the court's file. That's filing. Filing, all you have to do is follow the local rules, etc. I mean, it's not hard. It's not hard to file something.
It's not just a lawyer takes a case, and I'm not an attorney, so it's not just a lawyer.
It's not just a lawyer takes a case. I have no idea what that means. I think maybe he means that non-attorneys can take cases. I don't know about that, Sparky. You might want to run that past, I don't know, the state of Ohio or Indiana or whichever one CNH got popped in.
lawyer takes a case, what it is specifically, so you know, is the theory of law that you're using.
What it is specifically is the theory of law. Like, what does that even mean? This is all word salad. The guy has no idea what he's talking about. He's heard phrases and he's just regurgitating them back.
And how you're taking that case and what you're doing, how you're filing that paperwork.
How you're taking that case and what you're doing and how you're filing the paperwork. He has so little understanding of the practice of law that everything boils down to filing paperwork for him. That's a hell of a screenshot there.
And this is why we can help and assist with paperwork. So, hey, poor dirt farmer, good to see you, man.
How we can help and assist with paperwork. Hey, poor dirt farmer, good to see you, man. Yeah, again.
So we want to make sure that I want to talk to his mother and his brother, and then...
Yeah, he says over and over again, wants to talk to mother and brother.
Could use, our team is really big. We have a lot of people doing this. I told you guys yesterday, there's 7 different rooms of people who are
7 rooms of people. I have no idea what kind of metric that is. And what kind of people do you have? Do you have attorneys working for you? What kind of people? What qualifications are there? 7 rooms of people. What does that even mean?
We're all working together, and I certainly am not. I'm not the boss of anybody. I'm just the tip of the spear. The weight of the spear is you. It's not me. I'm just the tip. You are the.
We're playing just the tip. That's the biggest lie any man has ever told a woman. Just the tip. And he's telling a lie right now. He's trying to involve you, the audience, so that you feel like you're part of it. So you're going to be more willing to donate and give stuff. He's going to go on again to talk about the mother and brother here in just a second, apparently, because he really wants to get in touch with them. But yeah, it's just a tip.
The person of justice. We want to talk to his mother, his brother. We want to get in touch with him because, listen, we want this. Let me make clear. We want to take this idea on that your rights come to an end in a court of law.
So it's really stupid to frame the defense's argument before the defense gets it. Because the defense is not going to come out and say that your rights come to an end in a court of law. They're not going to say that. That is not going to be a theory advanced by the defense. I guarantee you that. They are going to say that, most likely they're going to say that the judge had the authority to do it, that there was a legitimate interest, a legitimate state interest, and that the judge's order was rationally related to achieving that legitimate interest. That is, I think, what they're going to argue. They're not going to argue that your rights come to an end in a court of law. And that is insane. Yes, he says it's insane. I agree. That's insane. Why are you saying insane things, Chilli?
That is insane. Now, do we want to be able to film the face of jurors? No, we don't. However, this idea...
What? Are you suggesting that perhaps there are more restraints on your First Amendment rights when you do get inside of a courthouse, and that a court can say that you're not allowed to film the faces of jurors? Is that what you're saying? If that is what you're saying, then, that sounds an awful lot like that there is some sort of a test, perhaps a forum analysis that the government can pass in order to enforce laws that restrict, or rules or regulations or orders that restrict your First Amendment. If the court can say you can't film the face of jurors in this courthouse, and you agree that the court has the power to say that, then the court has the power to limit your First Amendment rights inside the courthouse. He just agreed, he literally just agreed with the defense's position. And he doesn't even realize it.
That we have to pay for transcripts, and this is Susan Bassey stuff here. Susan Bassey, if you guys haven't watched her channel, go listen to Susan Bassey. She's so ahead of the game because she's being persecuted and prosecuted for taking a picture of a transcript. Now, I did look up Susan Bassey a little bit. Apparently, she got charged for something. I saw a clip, a newspaper article, where she was trying to take a picture of a transcript in a courthouse with her phone, and someone grabbed her hand, apparently broke her finger. She reported it to somebody, to the DA's office, and the DA charged her with taking pictures inside of a courthouse because there are rules in the Santa Clara County Superior Court about taking pictures in courthouses. And so she's facing criminal charges. Apparently, she also filed a lawsuit in federal court. It is still stayed pending the resolution of those criminal charges. Now, those criminal charges were back in 2017 or 2018. So, I mean, this is ongoing. I don't know what the hell's going on in her criminal case, but it is ongoing. And I would like to point out that Miss Susan Bassey is currently represented by a lawyer from a very elite firm, the Cochran firm. I think Johnny Cochran started the Cochran firm. I'm not entirely sure. But that sounds pretty darn elite to me. Before that, she had another attorney. So she gets attorneys. Now, why does she get attorneys if you think that CH shouldn't, if you're bringing her up? And what is the point? Persecute and prosecute for taking a picture. I guess she took a picture in the courthouse. I don't anticipate that she'll have much more luck in suggesting that there's a First Amendment right to take pictures of transcripts in courthouses.
They broke her hand. So we have...
And just so everybody's aware, for example, I don't know all the details. I don't know what transcript she took a picture of or whatever. But for example, in juvenile court, the court can limit access to who can see the file, and they can also limit access on who can have copies of the file, who can make copies of the file. I have seen more than one instance where the court has allowed the parents to have access to view the file. They need that access because they're the parents and they're going to be involved in the juvenile court process. But the court has not allowed them to make copies of it because for some reason they may have tried to disseminate copies or get the media involved or something like that. And so the court can and does have the power to limit the dissemination of some information. Now, I don't know all the details as to why. So I don't know what entirely was going on in Susan Bassey's case, and it's not really relevant, but I'm not entirely sure how it relates considering she's in California. I'm not entirely sure how it's going to relate to CNH. And you're going to say, well, because, your First Amendment right is, nationwide. And the problem is no court has ever found that courts do not have the power to restrict First Amendment activity within the courthouse. No court has ever found that. So, I mean, this would have to be you would have to literally convince the Supreme Court of the United States at the end of all of this that the Supreme Court of the United States did not have the power to control First Amendment activity in the Supreme Court. I don't think you're going to convince them of that. And since Marbury versus Madison says that they are the ultimate arbiters of what the Constitution is, what it means and what it doesn't mean, there is no review past the Supreme Court. And you would literally have to change the text of the Constitution. You'd have to have a constitutional amendment that passed, 3/4 of the states or something like that, ratified by 2/3 or 3/4 of the states, in order to get that constitutional amendment passed to now have the Constitution say what you want it to say.
I need to reach this guy. I need to reach his family. I can't tell you how far away I am. I'm somewhere in the...
Another plea to get to the family. I'm somewhere in the greater Toledo area.
The greater Toledo area. And so we want to reach this guy. They're trailing me. They're following me. I caught him on video yesterday. I lost a tail yesterday.
See, that I saw this part before, and I have no idea who they are. Who's this they who's following you, and why are you paranoid about it? Why are you paranoid? Who's they?
They're following me. They're straight up following me, man. I'm telling you. I actually...
Who's they? Why are we talking about people following you? I thought this was about CNH.
Pulled the video down so I could show you guys. They're following me around. So what that means is, and yes, he's in solitary confinement. I want to talk to his mama. I want to talk to his brother. I want to talk to someone.
Again. I want to talk to his mom and brother. Yeah.
And reach him so that we can file so we can help him file the paperwork properly, because it has to be done right.
The filing isn't the issue. It is making claims upon which relief can be granted and establishing the facts, alleging facts sufficient to allow a court to decide on a motion to dismiss that, assuming all the facts that are alleged in the complaint are true, could the plaintiff prevail? So this is very devoid of facts that are going to allow him to prevail. There are not a lot of facts that he alleges in here that I think are good, solid facts. So he doesn't allege facts well. He doesn't allege causes of action well. I don't know what grounds upon which Chilli can say that he can guarantee it's going to be done right.
Right. And you have to make sure. So I want you guys to do me a favor. Go listen to Clark versus Thompson. I want you to go listen to the case. I did a review on it, but listen to how the lawyers argue the cases. They argue the cases where they just sit right down in case law. And I have just been a student, just learning. And then my guy, Bobby Law, and my guy, X-Factor.
I don't understand what he's trying to say. Yes, when you're arguing in front of the Supreme Court, when you're arguing in front of any court, you want to state the reasons that you prevail. You want to point to, if you can, case law, stare decisis, that says that your interpretation of the law is correct. If you can't find case law that supports you, you want to point to constitutions that say you're correct. If you can't find constitutions that say you're correct, you want to point to statutes that say you're correct. If you can't find any of those that say you're correct, you want to point to practice guides or any other authoritative source that may say you're correct. And if you can't point to any of that, you want to make a good argument for your position based on logic. So yes, any attorney is going to argue, especially at the Supreme Court level. Those attorneys have drilled this down and practiced for months before they get in front of the Supreme Court, and they know the entire panoply of cases that might even touch upon their subject. And yeah, they're going to be able to cite cases that, support each position that they have. Now, the Supreme Court isn't required to go along with their particular interpretations. And usually something gets to the Supreme Court because you have case law on either side. Usually, like, one of the big reasons that something will get to the Supreme Court is because cases have been decided one way in these circuits and the other way in those circuits. So there's a split between the circuits. And so the Supreme Court will take the case so that they can decide which way it should be decided, which circuits got it right and which circuits got it wrong. So each side is going to be able to cite case law on their side, and they're going to point to Supreme Court decisions which appear to support their side, and they're going to try to distinguish Supreme Court decisions that appear to go against their side. So yeah, that's the job of an attorney, is to know what the cases, what the relevant cases are and what they say, and how to argue to distinguish cases that don't say what you want them to say.
And my guys, we go so deep into...
And I don't know who Bobby Law and X Factor are. Hopefully they're attorneys, but we go into it so deep. I guess we're not playing just the tip anymore.
Do it so deep into the theory of law. And so...
Into the theory of what law? Into the theory of what law? So Thompson versus Clark, again, it was a Fourth Amendment case where a guy was claiming that he was being maliciously prosecuted. The question that got to the Supreme Court is that at least one district, I think it was the second district, required that there be some affirmative finding, basically that the defendant was innocent, and then he could file a 1983 case for malicious prosecution under the Fourth Amendment. And the Supreme Court, I think, got it wrong, because they said, well, we're going to look at it at what the elements of a malicious prosecution case are. And at the time that the 14th Amendment was established, the elements of a malicious prosecution case were generally these. And so you just had to prevail. You didn't have to show that, you were likely innocent or anything like that. And I think Alito got it right because he said, hey, malicious prosecution is not a Fourth Amendment issue. Fourth Amendment is probable cause. And so you really should have to just show that they lack probable cause, yada, yada. I think Alito had the better argument because I'm dumb and I actually like what the Constitution says. But that was Thompson versus Clark.
You know, real quick shout out to
I don't have a lot of time, but here's a real quick shout out.
Jane, to Pam, to Brian, to David, to Tim, to Luis, to Alan, to everybody who has shown support. I won't stop. And this case is what we want to happen.
You won't stop what? Talking?
Not to happen to CNH and TY audits. We don't want it to happen to a person. We want the case to be pushed forward so we get to the Supreme Court so we can show.
So again, to get to the Supreme Court, you have to lose at the trial court level. You have to lose again at the appellate court level. It gets expensive. And then the Supreme Court has to decide to hear your case. They have to grant your petition for certiorari. And then, even then, they might just write a quick slip opinion, saying that it was decided correctly or whatever. I mean, they might just basically kick it out at that point. That doesn't mean that you're going to get new case law just because you make it to the Supreme Court.
If they don't uphold the rule of law, if they don't uphold your constitutional rights, if they don't uphold the constitutionality of law,
and the constitutionality of law, he excited himself there. Hey, baby. He excited himself there with the constitutionality of law. Like, what the hell does that even mean? It's just word salad. Does anybody listening to him actually listen to the words he says? Because it's just gobbledygook. He doesn't say anything substantive. As much of this as I've listened to, nothing substantive.
Watching Brian on Here's the Deal just now. Brian, thank you for your amazing live video. I worked till 6 o'clock in the morning. I woke up at 1 o'clock, so I got 7 hours of sleep, man. I'm jazzed.
Who cares?
I am jazzed. And then because of my contributors, I actually got to check into a hotel room and sleep in bed. So I haven't slept.
So thank you for my contributors for giving me money. I got a hotel bed. Look at how poor I am. Except I had an iPhone 12 Max Pro, which obviously is not cheap. And even after that was confiscated by the police, or seized, I should say technically, seized by the police. Now he has another cell phone. Oh my.
Slept in the bed in about 5 days. It was the first night I got to sleep in the bed. So it was just absolutely amazing. I slept in my car and I slept.
First time he got to sleep in a bed in the last 5 days, he slept in a car. Who cares? Dude? I thought we were talking about CNH.
On a roll mat. So I don't care. I don't care. It's not about me. It's about us. And it's about CH and TY audits. That guy got hosed. That judge. And
it's not about me. It's about us. I keep talking about me, but it's not about me. It's about us.
Explain something to you guys. The judge, when he left his chambers, when he left the courtroom, he lost all power.
Judges don't lose their power when they leave their chambers. For example, just a quick example. In the middle of the night, if the police need a warrant, there is typically speaking going to be a judge on call in whatever jurisdiction they're in. And that judge is probably in bed, at home in bed. He's not sitting up at his what do they call it? I don't even remember what they call it at the judge's bench. He's not in the courtroom. He's not at his bench. He's in bed. Phone rings in the middle of the night. Police say, Your Honor, sorry to wake you up. We need a warrant to search this place. Here's my probable cause. Whatever. I saw people dealing drugs in front of it. We established it was drugs. We need to go in there and do a raid for drugs before they run off and hide the evidence or flush it or whatever. And then the judge will make an order. And that order is called a search warrant. Now, in order for Chilli's version of reality to be true, there would have to be something that would invalidate any orders that were made outside of the courtroom. And I don't know of such a thing. I really don't. So I'm going to go with you're wrong.
A judge walking around outside his chambers, he lost all power. CH and T.
That's bullshit. That's a flat lie.
Audits could have told him, go. I'm going to try to keep it clean.
And I would love to know if Mr. Decastro has any source he can cite, any case law, because remember, I always talk about case law and attorneys sitting in case law. What source he could cite for this particular assertion that judges lose all power outside of the courtroom?
I don't like to curse when I see cops because I want them to know I can use any words I want. That's why I don't censor myself when I talk to cops and I say F you and I say you piece of garbage and I call them the worst names.
But it's not about you. It's about us, right? It's about CNH.
But you notice when I talk to you guys live, I really try to make sure I keep my language clean because I want the kids to be able to hear. But I also want the kids to realize there's a time to use vulgar language towards these people who say that they're for rule of law, and they're not. They're not. We just saw that with CH and TY audits. But we want to get that. We want to get that. We want to get that. And you don't want to trust any of these.
We want to get that. We want to get that. We want to get that. Yeah. The royal we, I'm assuming.
There's some lawyers you can trust, just not very many. They don't care. They don't really care. They don't really care. It's not.
Yeah, there's some lawyers you can trust, just not many. How do you find a good one? You know, I mean, she had two. You know, you look at the fence, they always have lawyers. Like whenever you sue cops or the city, they're going to get a lawyer. Why are they going to get a lawyer? Well, because they want to prevail. That's why. And additionally, you know, lawyers have the ability to figure out whether or not your case is good and know when to settle it. Know how much to settle it for, or at least have an idea of how much to settle it for, or when to settle it.
Their life's passion. They want to be in the top 1% of moneymakers. That's what they want.
Oh yeah, they just want to make money. Here's my subscribe button. You know, I take super chats. It doesn't look like he's got any yet, but he takes super chats.
That's what they want to do, and they don't really care. They don't love it. You know, they don't love it. They don't. They just don't.
How do you know? Like I actually started practicing law because I love the law. That's why I chose to return and actually take the bar exam and become a lawyer. It's because of arguing with idiots like you on the internet, where they're arguing legal principles that they didn't understand. I found that I actually liked reading cases. Now, admittedly, practicing the law, you read so many cases that it loses a bit of its charm, and you much rather go to a practice guide and just like get to the nitty gritty of things. But that being said, it's enjoyable to practice law, not just because you make good money doing it. It's enjoyable to practice law because, you know, you like to win, you like to argue, you like to represent your client and get the best deal you can for them. You know, there's a lot of positive things to being an attorney. And I don't know of many attorneys who are in the top 1% of moneymakers. I mean, you know, there are some who do very well for themselves. But if you look at like a lot of like DAs and public defenders, they make, even in California where it's pretty expensive, where I live, you know, they make somewhere between $6,000 and maybe $10,000 a month, which is not a lot of money. It's absolutely not a lot of money. Not for California. You can make way more than that being a private practitioner. And why do they do it? And a guy I worked with, an attorney, he was doing very well in private practice, and he worked for another attorney. So he was part of a law firm. And he was doing very well in it. And he had the opportunity to start a law firm with another guy I know. And he decided that he just wanted more court time. He just wanted more court time. He wanted to be in court arguing. And so he took a job as a public defender, because as a public defender, especially as a beginning public defender, you spend your day in arraignments. You know, you spend your day arguing motions and things like that. You're in court. You're in court just about every day for hours every day. That's what he wanted. He did it for the love. Oh, yes, I know, honey. I'm sorry. Well, my dog's starting to bug me, so I think I'm going to cut this off. I think you get the idea. Oh, yes, I will spend time with you. I think you understand where I'm going with this. He's not accountable to anybody. He doesn't really appear to know what he's talking about. I haven't seen anything to suggest that he knows what he's talking about. In fact, he goes on later to suggest that... I don't even remember where I was going there. It was something about Thompson versus Clark. He said something really stupid about Thompson versus Clark. I don't remember exactly what it was. Anyway, so there's your Chilli Decastro. Unless he actually ever makes some, affirmative statements and tries to back them up with some sort of case law, I'm not really interested much in him. He appears to just be a grifter. I guess he was a Power Ranger at one point in time. Power Rangers have really gone downhill, I guess. He just is trying to suck up money from people. He doesn't seem to offer anything of any value, and he's certainly trying to get paid. Thanks for watching. Have a great day.